If you have not completed, you can wait outside and you can complete. Yes, yes. Thank you. Shall we start? Okay. In India, the judicial review implies. Okay. As you all know, what is judicial review? Article 13. Okay. Article 12 defines state. Article 13 talks about judicial review. Is a judicial review common for Supreme Court and High Court? Do we have review power? It is. Yes, High Court does have judicial review. Okay. So, do we have anything called constitutional courts? No. Okay. So, what is the judicial review on? On the laws and executive actions, even on the delegated legislations. So, laws, delegated laws, rules, and the executive actions, everything is under judicial review. And every state will be under judicial review. But what is state? It would have been defined in Article 12. Does it include BCCI? If it is completely funded by government, then it is also a state, or it is performing the function of the state. Even an NGO can become a state. Okay. Of course, you know state, legislative, executive, but this Article 12 does not define judiciary as a part of the state in Article 12. But when we study state, we also include judiciary. But in Article 12, it does not define judiciary as a part of state. But it includes even NGOs or any organizations, if at all they are completely funded by the state or they are in association with the functioning of the state. And even if it is a PPP model, it is also under judicial review. Okay. So that's a simple question. So A, the power of the judiciary to pronounce upon the constitutionality of laws and executive orders. So it determines the constitutionality, whether the principles and the letters, that is the letter and the spirit of the constitution has been obeyed, especially upon the fundamental rights and basic structure of the constitution. Okay, so it is called usually test wires. Okay, test wires. Okay, if it is not satisfying the test, it will be declared as null and void, or it is considered as unconstitutional. Okay, so the answer is A. 2. In the first question itself, B. Okay, wisdom of the laws. Is there any other provision talks about wisdom of the laws? There is no exact word of wisdom of the laws, but we have fair laws. That is understood by the due process of law. Okay, under Article 21, we consider the due process of law. Okay, so we will test whether the law is fair. Okay, fair and proper. Okay, and then okay, is the judiciary involved in the assent? I mean, is the judiciary involved before the assent? No. Okay, power of the judiciary to review its own judgment? Yes. Okay, so in the D section, if you understand, okay, in the Nalsa case, if you consider in the section 377 case, okay, that is criminalization of homosexuals. If you understand, okay, the judgment went for a review judgment. And later, it also went for a curative judgment. Okay, அதாவது section 377 வந்து recriminalize பண்ணிட்டாங்க. அதாவது High Court, Delhi High Court said it is not a criminal offense. But later when it went to Supreme Court, it said it's a criminal offense. But later they went for a review petition and then they went for a curative petition. Okay, so there is Supreme Court has the power to review its own judgments. Okay, அதாவது அது சொன்ன விஷயத்தையே அதை reconsider பண்ணி it will declare its own, it will amend those errors in the laws. Okay, கடைசியா என்ன? Curative petition முடிஞ்சிச்சு. Yes, of course. What is the last resort? President's mercy petition. Okay. Apart from the judiciary, even if the top curative petition is also exhausted, you have to go with the president with the mercy petition. Okay. And then second question, who is called the custodian of the Constitution of India? It's simply guardian, and the custodian of the Constitution of India is the Supreme Court of India. Okay. But of course, in the oath of the president, it would have been mentioned that he has to uphold the Constitution. But under Article 13, again, the custodian is the Supreme Court, because he is the final interpreter and he is the final savior of the Constitution. Supreme Court. Okay, the answer is 2D. So the answer for 1 is A, 2 is D. 3. With reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. So it says that, let me try this once. I'm unable to display the question. Okay, what is the question? Third question. Okay. So it says prohibition or limitations or provisions contained in ordinary laws, which mean any of the laws, even if it is limiting, judiciary cannot be limited. For the sake of complete justice, okay, for the sake of complete justice, the judiciary can give any orders under Article 142. Okay, so only that it is called as judicial activism. If it is too much overriding on legislature or executive, அதாவது ஜுடிஷியரி சில விஷயங்கள் பண்ணும்போது தேவையில்லாம அதாவது லெஜிஸ்லேச்சரோட இல்லைன்னா எக்ஸிக்யூட்டிவோட டொமைன்ல கைய வச்சா, then you call it as judicial overreach. Okay, ஆனா லெஜிஸ்லேட்டிவும் எக்ஸிக்யூட்டிவ் சில விஷயங்கள் பண்ணாம இருக்கிறதுனால ஜுடிஷியரி அங்க கை வச்சதுன்னா then it is called judicial activism. Okay, fine. So the answer is Supreme Court, the B. The Supreme Court of India is not constrained in the exercise of its power by laws made by the Parliament. In order to write it down, in order to get the complete justice. So complete justice அந்த வார்த்தைக்காக ஜுடிஷியரி எந்த ஒரு ஆர்டரும் கொடுக்கலாம் அப்படின்றதுதான் ஆர்டிகல் 142ல சொல்லியிருப்பாங்க. ஓகே, சோ அதனாலதான் அந்த நிர்பயா ரேப் கேஸ்ல எல்லாம் பாத்தீங்கன்னா அவங்களே ஒரு ஜஸ்டிஸ் வர்மா கமிட்டின்னு ஒண்ணு போட்டு they will review this criminal laws. ஓகே, இந்த மாதிரி நிறைய விஷயங்கள் பண்ணிருப்பாங்க. 100 அந்த ஹைவேஸ்ல வந்து பாத்தீங்கன்னா 100 மீட்டர்ஸ்ல வந்து எந்த பார்ட்ஸும் இருக்கக்கூடாது அப்படின்னு சொல்லியிருப்பாங்க. நிறைய விஷயம், ஈவன் இந்த நேஷனல் ஆந்தம்க்கு எல்லாரும் தியேட்டர்ல வந்து எந்திரிச்சு நிக்கணும்னு சொல்லுவாங்க. இதை நீங்க ஜுடிஷியல் ஓவர் ரீச்னு சொல்லலாம், ஓகே, ஆக்டிவிசம்னு சொல்லலாலும் ஓகே. இட் இஸ் பேஸ்ட் ஆன் யுவர் கிரிட்டிசிசம். ஓகே, fourth question. With reference to the Gram Nyayalaya Act, which of the following statements are correct? As per the Act, Gram Nyayalayas can hear only civil cases and not criminal cases. It's not true. It can hear both. Okay, and it is bound by the principle of natural justice and not the code of civil procedure or evidence rules. So it's not bound by evidence rules or code of civil procedures, but by principle of natural justice. And it can, usually it will be under the, okay, this Gram Nyayalaya Act, if you understand, you all know in the Panchayat Raj there are 3 levels. What is the first level? Gram Panchayat, Panchayat Samiti, Zilla Parishad. So usually the Gram Nyayalaya is set at the intermediate level. Okay, it is set at the intermediate level. Okay, and it can adjudicate on any cases. Okay, usually the small civil cases, criminal cases, and every cases. Even they can go to the villages and like in the Panchayat Talaivar Madri, they can go to the villages, form a group, and they can, other than the Gram Sabha Kupta, they can adjudicate on any disputes. Okay, and they can actually conciliate, or they can even appoint a conciliator and resolve the cases. Okay, fine. And of course, if you have any appeal, you can go to the higher courts. Not higher courts, the lower courts. I mean the district courts and all. And so if it is a criminal case, the appeal goes to session courts. If it is a civil case, the appeal goes to district court. Okay. And there is a general supervision by the high courts. Okay, in the நியாயாலயஸ் எல்லாம் வந்து பாத்தீங்கன்னா district court and the higher courts வந்து supervision பண்ணுவாங்க. Okay, fine. So the answer, the first part is wrong. Second is the act allows local social activists as mediators or reconciliators is true. So second is true, one is wrong. So the answer for 4 is B. 4 is B. So next is 5th question. With reference to the Indian judiciary, consider the following statements. 1. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with prior permission of the President of India. Yes, there are 2 types of appointment: acting judge appointment, ad hoc judge appointment, and then even retired judges can be appointed. Okay, so as you all know, if there is any quorum, inadequate quorum also, they can actually get their support. So 1 is correct. They need permission from the President as well as the Chief Justice of India is the one who appoints. Second, a High Court in India has the power to review its own judgment as the Supreme Court does. Actually, you have the appellate as Supreme Court. Okay, the High Court has its own review jurisdictions, but it does not have as much as Supreme Court. So the 1 is correct, second is incorrect. Okay, you go to the appeal for review. Okay, அதாவது ஏதாச்சும் ஒரு கேஸ் இருந்தது, எனக்கு இந்த ஜட்ஜ்மெண்ட்ல விருப்பம் இல்லைன்னா you go to the Supreme Court. Okay, 5th one, 1A. A1 only. 5th one, A1 only. 6th one, there was a dispute. In the question கொஞ்சம் clear இல்ல, but இருந்தாலும் இதுல வந்து பாத்தீங்கன்னா power to review its own judgment is not as Supreme Court doesன்றது தவறு. Okay, as Supreme Court, it has review, but not as Supreme Court. 6th one, with reference to Constitution of India, consider the following statement. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. We all said judicial review is on the both High Court and Supreme Court. So 1 is incorrect. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Never. Again, even the amendment is also under the purview of judicial review. Okay, this was after a lots of case. Okay, Keshavan and the Bharati case ku munadi nariya kada nadandhirukum. Okay, so 6, neither 1 or 2, D. So 6, the answer is D. 7, the 44th Amendment to the Constitution of India introduced an article placing the election of the Prime Minister beyond judicial review. It is 39th Amendment. Okay, 44th, if you all see, it is all during the Indira Gandhi government where lots of havoc's done. Okay, 44th appa yaar irpa? In the government, Janata Dal government. Okay, so it is 39th Constitutional Amendment. Okay, so 1 is wrong. Second, the Supreme Court of India struck down the 99th or male edikonga, it is also 124th. Okay, adu enadhu? NJAC, National Judicial Appointments Commission. Adu vandu it is affecting the judicial independence அப்படினு சொல்லிட்டு they struck down the 99th Constitutional Amendment. Okay, what they said actually, we will reform this collegium system no சொல்லிருப்பாங்க அதுல. Okay, we will have a memorandum of procedure to amend the collegium system சொல்லிருப்பாங்க, ஆனா இன்னும் அது வரல. Okay, கொஞ்சம் மெரிட்ஸ் கொண்டு வரணும், டிரான்ஸ்பரன்சி கொண்டு வரணும். இப்பதான் collegium systemல கொஞ்சம் டிரான்ஸ்பரன்சி வருது. Okay, so 1 is incorrect, 2 is correct. So answers for 7 is B, 2 only. 8, consider the following statements. So the motion to impeach the judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act. No, lots of things has been rejected by the Speaker itself. அதாவது ஒரு விஷயம் நீங்க ரெசிக்னேஷன் கொடுத்தா கூட, இப்போ திடீர்னு ஒரு எம்பிஸ் வந்து ரெசிக்னேஷன் கொடுத்தா கூட it can be rejected. Just like that, judges removal procedure ஆரம்பிக்கணும்னு சொல்றத கூட நீங்க ரிஜெக்ட் பண்ணலாம். Speaker can reject. Okay. So first is cannot be rejected is correct, incorrect. Second, the Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior is not defined. The details of the process of impeachment is in Judges Enquiry Act 1968. Yes. Okay. என்னென்ன கண்டிஷன் மட்டும்தான் கான்ஸ்டிடியூஷன்ல சொல்லிருக்கு, மிச்ச ப்ரொசீஜர்லாம் என்ன சொல்லிருப்பாங்க ஜட்ஜஸ் இன்கொயரி ஆக்ட் 1968. ஆக்சுவலா இந்த 99th அமெண்ட்மெண்ட் என்ஜேஏசி ஓகே இது ஓகே இது வந்து அப்பாயின்மெண்ட்டுக்கு. We also have another bill. It's still not coming into force. It's called Judicial Accountability Bill. இது வந்து நீங்க பிஆர்எஸ்ல பாத்தீங்கன்னா இருக்கும், ஆனா அது வந்து பாத்தீங்கன்னா நம்ம எடுத்துட்டே வரல. ஓகே அதுல அது வந்து பாத்தீங்கன்னா இந்த ஜட்ஜஸ் இன்கொயரி ஆக்ட வந்து அமெண்ட் பண்றதுக்காக ஒரு பில் வச்சிருந்தோம், பட் அதை நம்ம திருப்பி கொண்டு வரவே முடியல. It lapsed. Okay. So the details in the process, okay, 3 is correct. If the motion for impeachment of a judge is taken for voting, the law requires the motion to be backed by each house, supported by a majority of total membership of that house by not less than 2/3 of the total members of the house present and voting. So it's a special majority. It's a correct answer. So answer is C. 1, 2 is wrong, 3 and 4 is correct. Okay, 8th. Okay, as you all know, it can, the judges impeachment judges removal. You can't call it impeachment. Judges removal, speaker allow பண்ணாதா உள்ள வரும். லோக்சபாலையோ ராஜ்யசபாலையோ எங்க வேணாலும் நீங்க இன்ட்ரோடியூஸ் பண்ணலாம். When it is happening in the Lok Sabha, then there will be an inquiry. Okay, inquiry நடந்து முடிஞ்சோன்னா next ஹவுஸுக்கு போகும். ஹவுஸ்ல வந்து பாஸ் பண்ணுவாங்க. Then it is okay. Special majority. ரெண்டு ஹவுஸ்லயும் special majority. 9th, pursuant to the report of H.N. Sanyal Committee or Sanyal Committee, the Contempt of Courts Act 1971 was passed. So இங்க ஒரு புது கமிட்டி நம்ம பார்க்கிறோம், H.N. Sanyal Committee. Contempt of Courts Act 1971 article என்ன article based வந்தது 129. Okay, so this is correct. Second statement, the Constitution of India empowers the Supreme Court, High Court to punish for the contempt of the selves. Yes. The Constitution of India defines civil contempt and criminal contempt. No. Okay, there are 3 kinds of problems. If you are disrupting the judiciary proceedings, if you are disobeying the judiciary proceedings, if you are acting in not in discipline, so these are all the civil and criminal contempt. ஆனா இதுல எது criminal contempt? Disobeying interfering disrupting disobeying is civil contempt. Actually நம்ம அப்படிதான் நினைப்போம், disobeying the criminal நினைப்போம், ஆனா disobeying is a civil contempt, disrupting the criminal contempt. Okay, the Constitution, okay, the third statement, Constitution of India. Okay, fourth, in India the Parliament is vested with the powers to make laws from the contempt of the court. Yes. So 1, 2, 4 answer is B. 10th, with reference to India, consider the following statements. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. No. Everybody is an advocate if they are getting the recognition from the BCI. Okay, Bar Council of India. Write this down. Bar Council of India is a statutory body formed under Advocates Act 1961. Okay, BCI is a statutory body formed under Advocates Act 1961. Similar to UGC, this National Commission of Women, it also frames professional standards. It will conduct this All India Bar Examination. It will conduct All India Bar Examination. It will give recognition to the advocates. It will set to the professional standards. It will also recognize the universities of law. It will also supervise those universities whether they're meeting the standards of education. Okay, these are all done by the Bar Council of India. But remember, Bar Council of India is also a pressure group. Okay. Fine. With reference 10th, with reference to the India, consider the following statements. Government, okay. So this answer is 10th is B2 only. 11. In India, legal services authorities provide free legal services to which of the following types of citizens? So, free legal aid, in the DPSP 39A. Okay, Article 39A. So, we created NALSA. We have different layers, NALSA, SALSA, TALSA, DALSA, நிறைய இருக்கு. Supreme Court லயும் Legal Services Committee, High Court லயும் Legal Services Committee ஒன்னு இருக்கு. Okay. So, who are the eligible one? It is SC, ST, disabled, women and children. இது ஒரு category. Okay. அதுக்கப்புறம் trafficked, victims of disasters, இதெல்லாம் வந்து ஒரு category. Okay, even the forced labor, beggars, இவங்கெல்லாம் வந்து ஒரு category. அதுக்கப்புறம் Supreme Courtக்கு போகணும்னா, அதாவது if you are going to the legal aid in Supreme Court, their income should be less than 5 lakhs. And for any other court, as per the state determines. எந்த income criteria வந்து state will determine for other courts. But for Supreme Court, it should be less than 5 lakhs. So here, 1, correct. 2, transgender, yes, they are involved. Okay. 3, OBC is not mentioned. 4, all senior citizens is not the thing. So 1 and 2 only. So 11 A. So 11 is A. இந்த மாதிரி எல்லாம் இப்ப ஹைகோர்ட்டுக்கும் பாத்தீங்கன்னா ஒரு லேண்ட் டிஸ்பியூட்னா என்ன அளவுக்கான லேண்ட் டிஸ்பியூட் ஹைகோர்ட்டுக்கு வரலாம் அப்படின்னு இருக்கு. டிஸ்ட்ரிக்ட் கோர்ட்டுக்கு எவ்வளவு அமௌண்ட் ஆஃப் லேண்ட் டிஸ்பியூட் வரலாம்னு இருக்கு. ஓகே, ஈவன் இஃப் இட் இஸ் அஃபென்ஸ், ஈவன் இஃப் இட் இஸ் தெஃப்ட், இந்த அளவுக்கு தெஃப்ட் இருந்ததுன்னா எந்த கோர்ட்டுக்கு வரணும் அப்படின்றதுலாம் இருக்கு. ஓகே, அவ்வளவு டீப்பா கேட்க மாட்டாங்க, நம்மளும் திடீர்னு கேட்டாங்கன்னா அதெல்லாம் நம்ம படிக்கணும். ஓகே, 12. Consider the following statement. Election of Commission of India is a 5-member body. It's a 3-member body now. It was 1-member body, later 3, 1, 3. Okay. Union Home Ministry is the one who provides election schedule? Not at all. So 1 is incorrect, 2 is also incorrect. 3. 12th question. 3. Election Commission resolves the disputes relating to splits and mergers of recognized political parties. Yes. So the answer is, wrong. 12, answer is 3. So the answer is D. Okay, இல்ல தப்பா கொடுத்திருக்காங்க. So answer is D, 3 only. 12, answer is D, 3 only. Okay, if you understand, even the AIDMK வந்து ரெண்டு பேரும் ஸ்பிளிட் ஆனாங்க, எங்களுக்கு தான் ரெட்டல வேணும் அப்படின்னு சொல்லிட்டு சண்டை போட்டாங்க. So actually this Election Commission of India only should have to resolve it. Okay, ஆனா அவங்க கோர்ட்டுக்கு போவாங்க. But ultimately the administration side யார் பாப்பாங்கன்னா Election Commission. Okay, even உங்களுக்கு தெரியும் சிம்பல்ஸ் எல்லாம் கொடுக்கறதும் அவங்க தான். 14. Consider the following statements with reference to high courts. Statement 1. The salaries and pensions of the judges of the high courts are charged on the Consolidated Fund of India. It is only the pensions. Sorry. 13. Consider the following statement with reference to the tribunals in India. The tribunals were not part of the original Indian Constitution. Yes, of course, if you see CAT and SAT, it is from Article 323 A and B. If you see ISWT, okay, it is not directly given in the the Constitution. It is only created by Parliament by law. Okay, any other tribunals in the Constitution? What is CAT, SAT? அதுக்கப்புறம் ஆனா இதுமே Parliament by law தான் கிரியேட் ஆகும். It's not a constitutional body. It's a statutory body. CAT and SAT is a statutory body. ISWT is also statutory body. Is there any other tribunal mentioned in the Constitution? Pardon? That's totally not mentioned in the Constitution at all. It's a statutory body. Okay. So, the tribunals were not part of the original Indian Constitution is true. 2. Appeal against tribunal orders only lie to the Supreme Court? No. Write this down. L. Chandrakumar case. L. Chandrakumar case says many things. 1. Tribunal appeals will go to the High Court. It cannot override High Court and go to Supreme Court. அப்படின்னா அந்த Chandrakumar caseல சொல்லிருப்பாங்க. Next is, there is a supervision. Okay, so tribunal is also under the supervision of higher courts. And also the tribunals, okay, cannot test his own law. அதாவது எந்த law அதை கிரியேட் பண்ணுச்சோ அந்த law அதுவே டெஸ்ட் பண்ணக்கூடாது. Okay, so this is all mentioned in the Chandrakumar case. Right? Chandrakumar case. So the appeal will go to High Court from the tribunal and then only will go to the Supreme Court. Okay. And always tribunal is a supplement to High Court and not a substitution to High Court. Idha mention pannirpaanga Chandrakumarla. Okay, so the answer is 1 only. 13 answer is A 1 only. Okay. 14. Consider the following statement with reference to the higher courts. Okay, high courts. See, high court matana. Higher court na Supreme Court and High Court. Okay. Statement 1. Salaries and pensions of the judges of the high courts are charged on the Consolidated Fund of India. Pardon? Fund of India andradhu tavaru. Okay, adum tavaru. Salaries illa, pensions mattumda. Adum tavaru. Pension vandu charged. Ana adu charged on the Consolidated Fund of the states. So one is totally incorrect. Statement 2 அப்பனா கரெக்டா தான் இருக்கணும். ஆனா என்ன பிரச்சனைனா இங்க ஒரு சின்ன ப்ராப்ளம். ஓகே, salaries and pensions of the judges of the High Court are decided by the Parliament. அதுவும் தவறுதான். ஓகே, pensions of the judges of the High Courts it's a charged expenditure இருக்கும்போது எப்படி அது decided by the Parliament இருக்க முடியும்? Statement 2 தவறுதான். Statement 2 is not properly made. Remember that first statement வந்து salaries totally is not a charged expenditure. Okay, pension is a charged expenditure, but it's a charged expenditure on Consolidated Fund of State. அப்பனா it is not decided by the state legislature. It is only passed. It's not voted. Okay, decided பண்ண மாட்டாங்க. Okay, so the second statement is of course is wrong. புரியுதா? 14th question, the question is that itself is having a problem. 15th question, consider the following statement with reference to the jurisdiction of court. Original jurisdiction means only that case can go to that particular court. That is original jurisdiction. Sorry. First எடுத்தோனே நீங்க அந்த கேஸ்க்கு போலாம். அதாவது ஒரிஜினல் எக்ஸ்க்ளூசிவ் ஜூரிஸ்டிக்ஷனா தான் you can only go to that. ஒரிஜினல் ஜூரிஸ்டிக்ஷனா ஃபர்ஸ்ட் எடுத்தோனே அந்த கேஸ் டிஸ்பியூட்னா நீங்க யார்கிட்ட போலாம்? ஓகே, to the Supreme Court. Okay, original jurisdiction means a power to hear such disputes in the first instance and not by the way of appeal. Okay, so first is correct. Exclusive jurisdiction means no other court can decide such disputes. Correct. 3. The high courts in India have the original jurisdictions to decide on election petitions in the parliamentary or assembly elections. Yes. 1, 2, 3, all are correct. So see all 3 for 15th question. Okay, all 3. 16th question. Consider the following statement. Independently elected members joins any political party. So, okay, let's talk about anti-defection. Anti-defection says, it is in 10th schedule, it says that if you are a member elected from certain party, you can only be there in that party. You should not shift to another party. If you are a member nominated, you can join any party within 6 months. After that, you cannot. If you are an independent member, you cannot join party at all. Okay, and there are 2 things, split and merger. Okay, split was once considered as a no defection. Later, now it is a defection. Merger, it's not a defection if there is a sufficient numbers, 2/3 or 1/3. 2/3. Okay. So first statement, 16(1). Independently elected member joins any political party. Let's go to the question. In how many of the above conditions members can be disqualified on the ground of defection? So 1 is a defection. Second, voluntarily gives up membership is a defection. Nominated members joins political party after 6 months, also defection. So all 3 are defection. So C, 16 answer is C. Okay. Next is 17. Consider the following statements. How many of the powers of jurisdiction mentioned above are common to the both Supreme Court of USA and Supreme Court of India? Advisory jurisdiction, there is a similar jurisdiction like advisory, but it's not advisory. Okay, writ of certiorari வந்து அவங்களுக்கு இருக்கு. ஆனா அது அட்வைசரின்னு சொல்ல முடியாது. அட்வைசரினா நம்மளுக்கு எப்படி பிரசிடென்ட்டுக்கு சுப்ரீம் கோர்ட் அட்வைஸ் பண்ணணும் அந்த மாதிரி இருக்கா இல்ல. So one is not there. Two, special leave petition, Article 136, no, not at all there. Judicial review, yes, it is there. So the answer is only one. 17A, only one. Advisory jurisdiction, Article 143, special leave petition, Article 136, judicial review, Article 13. இதெல்லாம் ஏன் சொல்றேன்னா மேபி பிரிலிம்ஸ்க்கு யூஸ் ஆகாது, ஆனா மெயின்ஸுக்கு ஆர்டிகலை போய் சொல்ல 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 பழகினாதான் உங்களுக்கு மெயின்ஸ் யூஸ் ஆகும். ஓகே, 18th question. So 17th answer is A. 18th question. With reference to anti-defection law in India, consider the following statement. The law specifies that a nominated legislator cannot join any political party within 6 months. No, they can. The law does not provide any time frame within which the presiding officer has to decide a defection case. Yes. See, if you understand, ஆக்சுவலி ரெண்டு விஷயம் வந்து டைம் ஃப்ரேம் இல்லாதனால பிரச்சனையா நியூஸ்ல வந்தது. ஒன்னு, மர்சி பெட்டிஷனுக்கு எப்ப பிரசிடென்ட் ஓகே சொல்லுவாருன்றதுக்கு டைம் ஃப்ரேம் இல்லைன்னு ஒரு பிரச்சனையா வந்தது. ஓகே, அஜ்மல் கசாப் கேஸ்ல அது ஒரு பெரிய பிரச்சனையா வந்தது. அதுக்கப்புறம் பாத்தீங்கன்னா இந்த பிரிசைடிங் ஆபீசர் வந்து இந்த ஆன்டி டிஃபெக்ஷனுக்கு டிஸ்குவாலிபிகேஷன் பண்றத டிலே பண்ணுவாங்க. யூஸ்வலா எப்படின்னா ஸ்பீக்கரை டிஸ்குவாலிஃபை பண்ணணுமா இல்ல மெம்பர்ஸை டிஸ்குவாலிஃபை பண்ணணுமா அப்படின்னு ஒரு அஜெண்டா வரும். ஆனா அஜெண்டாவுக்கு ஓகே சொல்றது யாரு? ஸ்பீக்கர். தன்னையே டிஸ்குவாலிஃபை பண்ணணும்னு அஜெண்டா போடுவாரா? It happens. Okay. 18th answer is B, 2 only. 19th, same anti-defection law. The law applies only to the elected members, also nominated, also independent. So one is wrong. Decision of the speaker of the chairman on disqualification proceedings can be subjected to judicial review. Yes. இதே ஒரு கேஸ்ல தான் வந்தது. கிஹோத்தோ ஹோலஹெம். ஓகே, கிஹோத்தோ ஹோலஹெம் கேஸ் வாயில நுழையாது, பட் தெரிஞ்சுக்கோங்க. கிஹோத்தோ ஹோலஹெம் case. Okay, so 1 and 2, 1 is incorrect, 2 is correct. So the answer is 3. The law provides 3-month time frame. We know it is not. So answer is B, only 2. Oh, not correct. Fine. So not correct. 1 is not correct. Second is correct. 3 is also not correct. So B, only 2. Not correct, B, only 2. 15, sir, 19. With reference to the writs issued by the Court of India, mandamus. So what are the writs? Habeas corpus to have the body of, okay, mandamus to command. Huh? Oh, 19 முடிச்சிட்டேனா? ஓ 19 போட்டிருக்கா? ஓகே ஓகே. 20th question. ஆனா question கரெக்ட் தானே? question தப்பா? ஓகே. ஓகே. In the election of the Lok Sabha. Okay, இந்த question இல்லையா? Okay. Fine. In the election of the Lok Sabha or the State Assembly, the winning candidate. In the election of the Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Guys, there is 2 ways of election. One is fast post, first past the post. Then is system of proportional representation by single transferable vote. So in the SPVP ko, in the FPPP ko difference enna, the proportion of seats will be equal to the proportion of the number of votings. That is the proportion of the அதாவது எவ்வளவு ஓட்டு உங்களுக்கு கிடைச்சதோ அந்த ப்ரொபோர்ஷனுக்கு தான் உங்களுக்கு சீட்டு கிடைக்கும் எஸ்பிவிபில. ஆனா ஃபர்ஸ்ட் பாஸ் போஸ்ட் சிஸ்டம்ல அப்படி இல்ல. யாரு வின்னர், அதாவது இந்த பிரெக்சிட் வின் ஆச்சுல, 51% people voted for Brexit, 49% voted for no Brexit. ஆனா 2%ல Brexit வின் ஆயிடுச்சு. சோ அந்த மாதிரிதான் நம்மளுக்கு என்ன ஆகும், this first past post the system. அது நல்லதா கெட்டதா? ரெண்டுமே. ஓகே, சோ இந்த எலெக்ஷன் 50% வாங்கணும்னு அவசியம் இல்ல. நீங்க 10 வாங்குனீங்கன்னா 11 நான் வாங்கிட்டேனாலே வின்னர். ஓகே, சோ 1 is incorrect. Second, according to the provisions laid down in the Constitution of India, in Lok Sabha, the Speaker's post goes to the majority party and Deputy Speakers goes to the opposition. Of course, it's true, but not by the Constitution, but by the conventions. So second statement is incorrect, first is incorrect. So 20 answer is D, neither 1 or 2. Okay. So 21st question. The power to increase the number of judges, adane. Okay. The power to increase the number of judges in the Supreme Court of India is vested in the Parliament. Okay. So if it is, okay, tell me, power to create a common High Court, yarukku irukku? Parliament. Okay. Power to increase the number of judges in the, sorry, High Court oda strength yaar idu பண்ணுவா? High Court oda strength president பண்ணுவார். Okay. So 21 the answer is B, the Parliament. Okay. 22, consider the following statement with reference to district judges. The appointment of district judge shall be made by the governor of the state. The administrative control over the district court is vested with the governor of the respective state. Administrative control over the district court is with the high courts. District judge does not have a power to award a death sentence. They have, but they need to get the high court certification. Okay, fine, they have the power. Okay, நீங்க அந்த appellate jurisdiction போய் பாத்தீங்கன்னா தெரியும். High district court வந்து death, அதாவது death sentence மாத்தி acquit sentence மாத்தி death sentence கொடுத்தா you can go for a appeal. So district court வந்து அப்பனா என்ன பண்ணலாம், death sentence கொடுக்க முடியும். Okay, so the answer is only 1. The first statement is correct. Second statement is with the High Court. Third statement is not correct. They can give the death sentence. 23, consider the following statement with reference to the acting judge in the High Court. So appointment of the acting judge எப்போ நடக்கும்? When there is a problem with any of the judge. They could not continue. Okay. So acting judge cannot last more than a period of 2 years. Is it so? No. There is no conditions like that. Okay, there is no conditions like that. Okay, pardon? Is it so? Okay, I'll check. 23rd, I'll check. Okay. One possible cause of such appointment when a judge of the High Court is unable to perform. 2 is correct. 23, 2, only. Okay, 1, I'll check. Okay, 2 years. If it is 1 year, okay, but 2 years, okay, fine. 24, with reference to electoral reforms, person in 24, person in jail or police custody cease to be an elector. Therefore, they cannot contest election. They are an elector. Okay, they still exist in the thing, but they cannot vote, but they can contest elections. Okay, they can contest elections. The ceiling on the election expenditure of candidates of the Lok Sabha seat is uniform across all states? No. Okay, it depends on if it is a bigger state, bigger expenditure, because that cannot be done. So answer is neither 1 or 2, 24B. 25, consider the following statement with reference to the permanent Lok Adalats. So 25, permanent Lok Adalats have jurisdiction only over matters which are compoundable in nature. Yes, we discussed about this. Compoundable na பேசி தீர்த்துக்கலாம் அப்படின்ற பிரச்சனையை நம்ம லோக் அதாலத்துக்கிட்ட போலாம். Permanent Lok Adalat established under section 89 of the Civil Code of Civil Procedure, is it? No. NALSA Act. Okay, NALSA Act. Okay, so the one is correct, second is incorrect. So 25 answer is A. Okay. 26. Consider following statement with reference to the removal of the judges of the Supreme Court and High Court. So, judges order removal proved a misbehavior and incapacity. Violation of the Constitution யாருக்கு இருக்கும்? President. Only criteria for impeachment of president is violation of the Constitution. So, 1 and 2 only. So, the answer is B, only 2. 27. Consider the following statement with reference to the supervisory jurisdictions of the High Courts. So, High Court, they are asking. They're not asking the Supreme Court, they're asking High Courts. Military courts or tribunals are exempted from the such supervisory jurisdictions. Yes, it is for Supreme Court. Okay. An aggrieved party must have a file an application before the High Court for it to exercise the jurisdiction. Need not be supervisory jurisdiction, not go with the aggrieved party. Complaint redressal supervisor. நான் வந்து சூப்பர்வைஸ் பண்ணுவேன் எப்பயுமே நீங்க கம்ப்ளைண்ட் பண்ணணும் பண்ணாதான் வந்து சூப்பர்வைஸ் பண்ணணும் அவசியம் இல்லை so 2 is incorrect. It covers only judicial superintendents, not administrative superintendents. No, both. So the answer for 1 is correct. Sorry, they're asking incorrect. So 2 is incorrect. Okay, so first is incorrect, second is third is first is correct. Sorry, first is correct, second and third is incorrect. So the answer is B, only 2. Okay, நான் எழுதி வச்ச அந்த question paper வீட்லயே வச்சிருந்தேன் அதான் பிரச்சனை. I'm with the நிறைய notes எழுதி வச்சிருந்தேன். I kept that. 28. Consider the following statement with reference to the removal of the judges of the High Court. Correct? 28th question தானே? A judge of the High Court can be removed from the office by an order of the President. A judges of the High Court can be removed from his office by an order of the President. Ultimately, yes. Actually, on the procedure சொல்றாங்க. Okay, procedure சொல்றாங்க. The resolution for the removal of the High Court judge must be passed by a special majority. Yes, special majority, which means total membership of the House. Okay, 50% of the total membership of the House and 50% of the, sorry, 2/3 of the present and voting. The only grounds for the removal is proven misbehavior or incapacity. So all 3 is correct. So 28D. 29. With reference to subordinate courts. Okay, first statement. As the highest judicial authority in the district judges possess original jurisdiction only. Appellate jurisdiction என்ன போச்சு? Of course, appellate must be there. So 1 is incorrect. 2. A session judge is empowered to award capital punishment. இப்ப அதுதான் பேசணும். So 2 is correct. So the answer for 29 is B, 2 only. 30th question. Consider the following statement regarding the power of the Supreme Court in case of contempt of court. So Article 129 has the power, the SC has the power to punish for the contempt of itself as well as for the contempt of higher courts and subordinate courts. Let's see. Yes, actually. The Constitution of India explicitly defines what constitutes contempt of court. No. Contempt of court can be for criminal matters only. No. So the answer correct and kekrano only 1. 1. 1 is first statement is correct. So only 1. A. 31. So they're asking about the Election Commission of India is responsible for holding elections to Panchayat and municipalities. No. It is State Election Commission. So 1 is incorrect. So the second is correct. Okay. So 31 answer is D. 32. Election Commission of India has the power to register and deregister. It has the power to register but not deregister. That is the problem. That is the problem. Okay. But it has the power to recognize and derecognize. Okay. Yes, that is true. 1 is incorrect. 2 is correct. 32 answer is 2. Because registering is simply allowing the party to contest. Recognition is when they get the sufficient votes and they become state party or national party. So 32 answer is B. 33. Which of the parties, which of the following cases can be recognized as a state party? If it wins 3% of seats, yes. If it secures 6% of valid votes, yes. If it secures 8% of votes, 8% la irukka? 1 and 2 only. So 33 answer is 1 and 2 only. Actually, ஒரு amendment மூலமா 2-3 தான் ஆட் பண்ணாங்க. அதுல அந்த 8% வருமா? வருமா? If it secures 8% of the total valid votes polled in the states at a general election to the Lok Sabha from the state. அது செக் பண்ணுங்க, தேர்ட் வருன்ற மாதிரி இருக்கு. ஓ 1 seat-ஆ? In addition. So let's keep this 33 hold. Okay. So national parties. Correct? Okay. 34th question. RPA 1951 electoral rolls or 1950 electoral rolls? 1950. So 1 is incorrect. So 34, 1 is incorrect. 2. General electoral rolls, general electoral rolls include all eligible voters residing in the country, while separate electoral rolls, separate தேவையில்லை. So second statement is incorrect. The constitution empowered the election commission to maintain the electoral rolls. Yes. So the answer they are asking for correct. So only the third statement is correct. 1 and 2 is incorrect. So state party order conditions பாத்துக்கோங்க. Okay. 35. How many of the following commissions electoral forms? நேத்து தான் நம்ம சொன்னோம். Questionல இருக்கு. All. 35 all 4. 35 all 4. Sorry, 35 all 4. 36. With reference to the systematic voters education and electoral participation, consider the following statement. It is the initiative for electoral education. It's launched by the election commission. Correct. Both are correct. 36C. 37. For the exit polls. What is an exit poll? What is an opinion poll? Actually, the first statement talks about opinion poll and not exit poll. Opinion poll pre poll அதாவது நீங்க எலெக்ஷன் ஓட்டு போடுறதுக்கு முன்னாடியே கேட்கறது. எக்ஸிட் போல்னா ஓட்டு போட்டு வெளியே வரும்போது கேட்கறது. ஆனா ஓட்டு போட்டு நீ வெளியே வரும்போது அந்த ரிசல்ட் நான் எப்ப சொல்லணும்? எல்லா எலெக்ஷனும் முடிச்சதுக்கு அப்புறம். ஓகே, அதுக்கப்புறம் தான் நீங்க வந்து அந்த எக்ஸிட் போலோட ரிசல்ட்டை வந்து சொல்லணும். ஓகே, so these are surveys on pre-poll. No. Exit polls of a particular constituency can be published after completion of voting in that electoral constituency. No. After every elections on all across finishes only they can display. So 1 is also correct. Sorry, 1 is also incorrect. 2 is also incorrect. So the answer for 37 is D. 38. Which of the following is the ground for the disqualification of membership of legislature under the RPA? See guys, ரெண்டு விஷயம். Disqualification actually 3 விஷயம். ஒன்று கான்ஸ்டிடியூஷன்ல சொல்லப்பட்டது, இன்னொன்னு இந்த ரெப்ரசன்டேஷன் ஆஃப் பீப்புள் ஆக்ட்ல சொல்லப்பட்டது, மூணாவது ஆன்டி டிஃபெக்ஷன். ஓகே, 3 டிஸ்குவாலிஃபிகேஷன் ப்ரொசீஜர்ஸ் இருக்கு. ஆர்டிகல் 102. ஓகே, 102 கான்ஸ்டிடியூஷன்ல சொல்லப்பட்டிருக்கு. நீங்க சிட்டிசனா இல்லனா அப்படிலாம். ஓகே, சோ ஆன்சர் conviction for a crime less than 6 months or no. It is for failure to submit election expenditure accounts within a prescribed time. So answer is B. Bombay. 38B. See, RPA la வந்து section 8 of 1, 2, 3 வந்து mention பண்ணிருப்பாங்க எப்ப நீங்க disqualify ஆவீங்கன்னு. 39. Okay. A citizen believes that. Okay. A citizen believes that the government official has assumed. Actually, 38 la வந்து ஏயும் தானே disqualify ஆவாங்க. 2 years அப்புறம் 6 years disqualify. ஆனா 6 months ஆனாலும் 6 months disqualification தானே. Less than 6 months நாலும் அந்த 6 months disqualified தானே. See guys, remember, more than 2 years நீங்க ஒரு imprisonment வாங்குனீங்கன்னா plus 6 years you will be disqualified. But even if otherwise, if you are 6 months நாலும் நீங்க வந்து உள்ள போயிட்டீங்கனாலே நீங்க வந்து அந்த 6 months நீங்க disqualified. Okay, maybe they should have changed the question like ground for disqualification for more than 6 years. For 6 years அப்படின்னு கேட்கும்போது yes, of course. Okay, 39. A citizen believes that the government official has assumed an office without the proper. See, B தான் correct. ரெண்டும் correct தான் சொல்றேன். B வந்து proper answer. Okay, 39. Okay, so ஒரு ஆபீஸ்க்கு வந்து உங்களுக்கு தகுதியே இல்லாம நீங்க போனீங்கன்னா நான் என்ன ரிட் போடலாம்? ரிட் ஆஃப் வாரண்ட். என்ன தகுதியோட நீங்க போறீங்க? வாட் வாரண்ட்ஸ் யூ டு பி தேர் இன் தட் சீட்? ஓகே, தகுதியே இல்லாம போறவங்களுக்கு ஓகே நீங்க அந்த பூஜா கேட்கறதுக்கு தாராளமா ரிட் ஆஃப் வாரண்டோ நீங்க போடலாம். ஓகே, சோ 39 ஆன்சர் இஸ் B. 40, which of the following statement is correct regarding the salary and allowances of Supreme Court of India? Okay, they are determined by the president? No. It can be altered by the parliament of the judge's disadvantage after his appointment? No. It is charged on the consolidated fund of state? No, it is India. B. None of the statements are correct. So 40 B. 40 answer is D. 41. Consider the following statements with reference to the various state level electoral offices. Chief electoral officers at the state level is appointed by the governor. Is it governor or ECI? Election Commission of India. You have to remember, election நடக்கும்போது எந்த ஒரு ஆபீசருக்கு சூப்பர்விஷனோ டிரான்ஸ்பரோ அப்பாயின்மெண்டோ எல்லாமே ECI தான் பண்ணுவாங்க. ஓகே, ஏன்னா எந்த ஒரு இன்டர்ஃபரன்ஸும் இருக்கக்கூடாது எலெக்ஷனுக்கு. கவர்னர் பண்ணாலும் அது ஒரு பொலிட்டிக்கல் இதுதானே, nothing doing. Okay, so all are done by first statement also done by ECI. Second statement nomination is also done by ECI. So answer is asking for not correct. So 41 answer is C. 41 both 1 and 2. Then so strength of the High Court is decided by the President of India. So the answer for 42 is B. 43. Which of the following statements are correct with respect to the High Courts of Union Territories? High Court of Delhi is established by Article 239A. அதுக்கு முன்னாடி இருந்துச்சு. Okay, fine. So 43(1). See guys, for the High Courts alone, if you understand, நம்மளோட pre-constitutional treaty actually follow பண்றோம். Okay, நம்ம pre-constitutional treatiesலயே so நம்ம pre-constitutionsல Government of India Act அதுதான் நம்ம actually follow பண்றோம் High Courtsக்கு. Establishing a High Court for Union Territory would require a constitutional amendment? No. So answer is neither 1 nor 2. 43 B. 44. Model Code of Conduct comes immediately into effect once a schedule of elections are displayed. So A. 44 A. 45. Again, Judges Enquiry Act. The presiding officer may admit the motion of removal. Yes. Second, President constitute a 3-member committee to investigate the complaint against the judge. Is it President? It's not President. President ulla varamatar. Motion for removal is required to be adopted by each house by absolute majority. No, it's a special majority. So answer is 1 only. 45. Answer is A, 1 only. So B, 1 only. 46. Consider the following statement with respect to the collegium system. It is mentioned in the Indian Constitution as a method of selection of judges of the Supreme Court. Mentioned in the Indian Constitution? No. Second, High Court judges are recommended by collegium comprising of CJI and 2 senior most judges. Yes. So 46 answer is B2. I already call the first statement it is by the judges case. Second judges case. Second judges case 1990s. 1993. Second judges case. Actually, in 1993 நிறைய நடந்திருக்கும். Even the Chandrakumar case 1993 தான். Okay. Second judges case. Okay. 46. 47. Writ jurisdiction. The writ jurisdiction of High Court is wider? Yes. Because writ of fundamental rights as well as writ of legal rights also. But Supreme Court வந்து writ of fundamental rights மட்டுமா பார்த்துக்க முடியும். So 47 1 is correct. Second, in higher courts, writ can be issued only against the violation of the fundamental rights. No, அதுதான். It is not only for fundamental rights, it's also for legal rights. Like right to property எங்க இருக்கு? Right to property article 300A ல இருக்கு. அதுக்கும் நீங்க writ போட்டு நீங்க high court கிட்ட போலாம். So the answer is 1 and 2. Oh, sorry, 2 is incorrect. So 1 only. 47A. 48. Special leave petition article 136. Article 136. Special leave petition should be distinguished. Sorry. Supreme Court may grant special leave to appeal from any judgment passed by any court in Indian territory except on laws of armed forces. Yes. Any territory, any judgment. Okay. It can be filed against any order of the High Court refusing to grant certificate of fitness for appeal to the Supreme Court. Actually, second statement is also correct. So the answer is C, both 1 and 2. 48, answer is C. Please mention. Okay, 48, answer is C. Both. Oh, sorry, sir. Yeah. At any time என்றது தவறு. Okay, நான் அதை mention பண்ணிருந்தேன். Yes. 90 days குள்ள வந்து அவங்க கொடுக்கணும். At any time என்றது தவறு. Actually 90 days குள்ள அவங்க வந்து கொடுக்கணும். Okay. 60 to 90 days. Okay, so the answer is A, one only. Oh, sorry. 48, A, one only. Okay, அதுதான் நான் mention பண்ணேன். I forgot the paper I told you, no. 49. Which of the following qualifications? So 60 to 90 days, I mentioned panikong. Okay. Which means 3 months. Which of the following qualifications or conditions are common for both Supreme Court and High Court judges? Should be a distinguished jurist. Distinguished jurist வந்து Supreme Court மட்டும் தான் இருக்கும். High Court இருக்காது. No minimum age for appointment. Yes. Advocate of a High Court or High Courts in succession for 10 years. Yes. So 2 and 3 only. 49, 2 and 3 only. Okay. 50th question. Which of the following is not the criteria for political party to recognize as national party? It is D. Delhi. Okay. புரியல. It is second. Post states are. No, post states are. Post states are. I'm sure. Other, I'm sure. So 50 answer is D. Okay, any doubts? Okay, we'll stop. Okay,